Our firm represents a lot of people who've been charged with either drug possession or drug trafficking, including possession for the purpose of trafficking. In fact, we do have former drug prosecutors who work at our firm who have experience as prosecutors and who are now our defense counsel. So the first question many clients ask us, as of all criminal charges, can I win this case at trial? And I want to refer you to another video. I did a video on how to get drug charges dropped. So this is assuming the Crown's not agreeable to withdrawing the charge, not agreeable to give us a great deal, diverting out of the system and avoiding a record, etc. So this is a case which, for example, I've reviewed and determined that the charges are somewhat defendable at a viable, at least 50%. I mean, I guess we sometimes go to trial on cases that are less than 50% odds, but most of my clients choose to for sure go to trial at 50%. So what do I do? What are the strategies? How do you win these cases? So, well, first and foremost, I get a hold of the disclosure. That is all of the police occurrence reports, police investigation, notes, surveillance, search warrants, you name it. Whatever the police have uncovered in their evidence, which has been provided to the Crown is required to provide to me. And sometimes that package can consist of only 100 pages, sometimes it's thousands in complicated cases. Drug conspiracies involving hundreds of pounds of cocaine, for example, is pretty complicated. You got wiretaps, etc. So how do we win these cases? Well, once I have the disclosure, once I have all the disclosure, I'm in a position to review the case carefully and see if the police, number one, made any mistakes. Are there some defenses that we can raise here? Is the search warrant valid? Did they have reasonable and probable grounds for the search? Did they have grounds to search a vehicle, or did they just wantonly search it? Can we exclude this at trial? One of the very most common defenses for any drug charges is it was an invalid search. So you would be bringing, if you determine as a lawyer that it's invalid search or the search warrant's not valid, you'd bring a Section 8 charter applications to challenge the evidence and exclude it at trial under Section 24(2) of the charter. This is very common in drug cases, there's no question, because the police do make mistakes. They fill out invalid search warrants on occasions without reasonable probable grounds. They search vehicles or people without reasonable probable grounds. And a good lawyer, if that happens, can often get that excluded and there's no case. So that's one defense. Another defense is where you're showing that the accused did not have knowledge and possession of the drug. So you need care or control, which requires knowledge and control of that drug. So, for example, a common situation is where a house is raided, there's multiple people in the home, one of your clients was in the home, maybe they live there, maybe they happen to be in the home. They're not going to be able to prove the case against them. It can't be shown that they had knowledge and control. It's found in one room, they're just at a party. What the police normally do is they charge everyone found in the house. They have to, because otherwise the guy charged points fingers at someone else. So that's a common scenario. That's also a common scenario in cars. When a car's pulled over and there's a drug found on the floor, they wind up charging everyone if it's not found in someone's pocket, for example. And even if it is found in someone's pocket, they may not have had grounds to charge them, and you can bring a charter application to get it thrown out. So there's that. And there's also situations where a person's charged with possession for the purpose of trafficking, but the indicia of the trafficking is not really there. I mean, they overcharge the person. You can win a trial to argue that it's just simple possession. They weren't trafficking that drug. The police overcharged. So all of these issues are discussed with the client at our initial meeting. That's one of many meetings that we use to prepare for trial, and dozens sometimes of meetings on a complex case, but handfuls of meetings even on a most minor charge. We have to prepare the client to testify in the month leading up to trial. That takes a lot of time as well. He or she needs to be properly prepared by the defense counsel. They need to go through examination in chief. They need to go through cross-examination, mock cross-examination, showing them their errors, how the Crown's going to attack them, and actually break them down in the office and build them up and make them a good witness. This is all part of defense counsel. You can't just put a person, even when a person's telling the truth, you just don't throw them up in the witness stand. They're going to be a disaster. A good lawyer, a good criminal lawyer, can destroy a truthful witness who's not prepared. It's as simple as that. I've seen it time and time again on the witness stand over the years. There's no question it happens all the time. So, the client, after my initial meeting, I want them to review that disclosure very carefully by themselves in the office. That may take multiple meetings if it's extensive. It may take 50 hours on a big case, frankly, but on a more minor case, it might take a day. They write their statement out for me. We then go through multiple revisions of that. I refresh their memory. We get it in the format we want. So the disclosure coupled with the client statement becomes my roadmap for defending the case. If it's an illegal search case, I file a charter application at least 30 days before the trial with case law, written submissions, and we argue that at trial to get the drug thrown out. If it's a lack of knowledge or possession case, we argue that at the trial. The client might testify, it's not mine, I didn't have it on me. It's a weak circumstantial case. There's many ways of attacking these cases, including often, unfortunately, attacking the credibility and reliability of police officers. I mean, police officers, just like a normal witness, we prepare for them. We try and create inconsistencies and probabilities in their version of events as well. So there's a whole host of ways to challenge and win, create reasonable doubt on drug cases. And I've gone through a few of them with you at this point. And I can tell you this, that, drug cases they fall under two categories. Usually it's often a very strong Crown case. I'm telling my clients to plead guilty. If there's gray areas of winning, we can often win those. And sometimes the Crown, as I said in my video about dropping the charges, if there's gray areas and reasonable doubt, sometimes the Crown will cut us a very good deal. Sometimes they'll even withdraw the charges if there's not a strong reasonable prospect. But these cases can often be won at trial in the hands of a good lawyer. It's very important to hire a lawyer who knows what the heck they're doing. There's thousands of cases on illegal searches, and if your lawyer knows them and can apply them to your facts, you can often win and create a reasonable doubt. The burden of proof is in your favor. The Crown has to prove the case beyond a reasonable doubt. So if the judge ultimately or the jury's not sure, they're not convinced beyond a reasonable doubt, you can win. If you take the witness stand and the judge can't completely reject your evidence, I don't even believe that person, but they're still left with a reasonable doubt for the rest of the case, you win. If you take the witness stand on the WD test for Supreme Court of Canada and, the judge says, I don't really believe the accused, but I'm left in some reasonable doubt, you win. In other words, the judge is saying you're probably guilty. That's why many of these cases can be won, because of our burden of proof and proof beyond a reasonable doubt. So that's a kind of a short summary of how we can potentially win your drug case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.